Hi, I am Ibrahim. My student ID is 0368041. Today, I'll be presenting my assignment topic, which is the distinction between the legal capacity required in making a will from declaring a trust and whether those distinctions are justified today. This topic is important since wills and trusts are two important legal tools in succession and property law. Both deal with the management and distribution of property, but each with different requirements of legal capacity. My presentation will be on the ability to make will, the legal capacity to do so, the capacity which is required to create a trust, the differences between the two, and whether such differences are still warranted in the present day. First, legal capacity is defined as the mental and legal capacity of a person to comprehend an action, its nature and effects within the legal field. Legal capacity in succession law means the ability of a person to be able to validly make a will or declare a trust. A will is a document that lets one tell how they want their assets distributed when they die. A person who makes a will is called a testator. Importantly, a will only becomes effective after death and can be revoked or changed while the testator is still alive. In contrast, a trust is a legal entity which places property in the control of trustees for the benefit of the beneficiaries. Generally, there are two important types of trust that are relevant to succession law. First, inter vivos trust, and second, testamentary trust. An inter vivos trust is created by the settlor while he or she is alive and convey rights and obligations of ownership immediately. A testamentary trust, on the other hand, is established by a will and only comes into existence after the person dies. So this makes testamentary trust and will very similar to each other. So the main difference from will in trust can be said is the inter vivos trust, which I will be addressing throughout this presentation. In general, the courts have higher requirements for declaring trust, as trusts can have immediate legal consequence and permanent transfers of ownership. First, I shall speak about testamentary capacity. Testamentary capacity is the mental state a person must be in to create a valid will. The primary case is Banks and Goodfellow. In this instance, the court determined that the valid testator must understand the nature and effect of making a will, understand the extent of the property involved, appreciate the claims of the potential beneficiaries, and not suffer from mental disorders affecting decision making. These principles still remains relevant today as they form a flexible and practical test for mental capacity. Testamentary capacity is not a general measure of intelligence or competence, but rather depends on the task specific, as said by Kennedy. He notes that the intention of the law is to have a lower threshold as the law goes into effect after the person's death and can be revised during their lifetime. The lower threshold allows for testamentary freedom but also safeguards those who are vulnerable from exploitations. Likewise, Vosco explains that testamentary capacity differs from contractual capacity because the testator only needs to understand the act of distributing property upon death. The law, therefore, is based on whether the person knew what was happening when he or she signed the will. The second most important guideline is the presumption of capacity. Presumption of testamentary capacity applies to adults in that they are presumed to have it unless evidence to the contrary exists. This illustrates the value placed on testamentary freedom, which is the right of the people to decide who is to receive their property, how the estate should be distributed, and which person should benefit from it. Generally, courts will not get involved in the wishes of the deceased unless there is a strong evidence that there is incapacity, fraud, or undue influence. As people get older and more people are diagnosed with dementia, there are more and more disputes relating to testamentary capacity, as explained by the systematic review published in the International Journal of Law and Psychiatry. This article provides an explanation to the fact that the inability to be mentally competent does not necessarily make a will invalid, as this incapacity can vary over time. For instance, Someone with dementia may be lucid at certain times and be able to make a will at those times but not at others. Courts thus check whether the testator had knowledge of the agreement when he or she signed the will. As Burns describes, current capacity evaluations require the collaboration of counsel, psychiatrists, and physicians. This interdisciplinary approach is particularly significant when involving dementia, Alzheimer's disease, and psychiatric illness. The golden rule in Kenward and Adams also serves a friendly reminder to solicitors to seek medical opinions when they are preparing will for elderly or seriously ill people. Millward also contends that the field of mental capacity law has become more functional rather than based on traditional dichotomy of competency versus incompetency. Testimony capacity is also a problem in Islamic succession law. In Islamic law, mental capacity is a requirement when making testimony dispositions, as stated by Balan. Likewise, Islamic law has laid stress on understanding, voluntariness, and understanding of legal implications. This shows that the issue of mental capacity is not unique to common law and is a general principle in succession law. Next, I will proceed to the legal capacity needed to make a trust. A trust is a legal vehicle in which trustees hold the property for the benefit of the beneficiaries. Many trusts are active immediately upon the formation and may be irrevocable transfers of properties, unlike wills. As a result, courts tend to have more stricter understanding requirement to declare a trust. Here, the settlor needs to be aware the type of trust relationship, the real estate that is being transferred, the rights of the beneficiaries, and fiduciary responsibility that trustees have to their beneficiaries. This is a higher threshold because of the immediate legal consequences of trusts. As explained by Kwa Wok Chin, trusts involve a distinction between legal ownership and equitable ownership, requiring more sophisticated understanding than ordinary testamentary dispositions. The settlor should be mindful that trustees can own the property. Those who receive the benefit are enjoying the benefits. The settlor's control over the property can also be lost forever. In addition to the above, trusts are typically more complicated than wills because they contain fiduciary obligations, discretionary powers, investment responsibility, and long-term management structures. These complications result in need for more understanding the settlor exhibits to the court. However, the distinction between wills and trusts is not always clear. A testamentary trust is the one that is established by will and will only be implemented after death. In those circumstances, the capacity is generally deemed to be the same as testamentary capacity as the trust is the testamentary disposition. Testamentary trusts, as Nell argued, overlap the boundaries between trust law and succession law since they are a mixture of the two. This illustrates that the line between wills and trusts is not always obvious in today's estate planning. The main difference between testamentary capacity and trust capacity is the effect of the transaction. A will is not legally binding until a person dies, is not irrevocable while the person is alive, and does not establish any rights for the beneficiaries. In contrast, some trusts may be able to transfer ownership rights immediately, establish legal binding commitments, and may be permanent restrictions on the right to own the property. Another key difference lies in complexity. A will is more basic document that is concerned with the distribution of the property after death. However, trusts can include complicated fiduciary relationships, structures for long-term management, and equitable interests. The distinction is warranted further by the questions of revocability. A will can usually be changed or cancelled at any time prior to death, and many trusts are said to be irrevocable once assets are given to the trusts. Trusts are therefore treated as more serious legal transaction than making a will and are therefore accorded greater considerations by a court. There are a number of arguments in favor of separating testamentary capacity from trust capacity. First, it is a very different legal matter. Whereas a trust can have an immediate impact on rights of ownership and establish binding obligations before death, a will only takes effect after death. Secondly, trusts are often more legally and financially sophisticated than wills. Thirdly, stricter trust requirements help to safeguard vulnerable person against being exploited, particularly in instances of substantial transfers of property made during the person's lifetime. Lastly, we have the freedom to make a will, which is safeguarded by the lower threshold. Contemporary scholars have, however, challenged the validity of the difference. However, according to Neil, trusts are often more successful alternative to wills in modern estate planning. It is if different standards are applied for different reasons due to legal forms, this can cause some inconsistencies and confusions. Medical scholars also question the conventional notions about mental competence. The International Journal of Law and Psychiatrist research indicates cognitive impairment is a spectrum and can vary throughout time. Modern legislations like Mental Capacity Act 2005 has a functional approach and asks whether a person is able to understand information, retain information, consider the factors that are relevant, and communicate decisions. This aligns with the current thinking on mental capacity better than the traditional categories, as Millward says. It is also noted that while an individual may have the capacity to make a will, they may not have the capacity to make a trust that does the same thing. So, to sum up, the legal capacity needed to make a will is quite different from what is needed to declare a trust. Testamentary capacity can be shown only to have acquired some knowledge of the aspects of the will making procedure, the property concerned, and the potential beneficiaries' claims. In contrast, trusts tend to be more complex to understand because they can involve legal duties that are binding, fiduciary responsibility that are created, and transfer of ownership rights immediately. The difference are mostly warranted as wills and trusts are legally different and their consequences are quite different. But in today's world, sharply divided standards are coming into question in light of growing willingness to replace wills with trusts and evolving knowledge about the pathological nature of cognitive loss. It seems that the traditional categories may need to be revised in the future. Finally, a more functional and transactional legal capacity regime might offer greater uniformity and equity in succession law. Thank you.